We are joined by the Assistant Attorney General, Harmeet Dhillon, in charge of the Civil Rights Division. Thank you so much for joining. Really appreciate you taking the time.
Thanks for having me today.
So, broad strokes, before we kind of get into some of the nitty gritty of it, what is your office working on specifically? Obviously, civil rights is a huge and broad topic, but I think the forefront at this point in time, or at least how I see it, is all of this DEI initiative stuff and dismantling it around the countries and more specifically at the universities. Can you tell us about that?
Well, DEI is a concept. I mean, over the years, it's been called different things. Equity and affirmative action as a tool of accomplishing this so-called equity goal. But really, what it is a way to balance outcomes as opposed to opportunities. And I think that over the years, courts have really cut back on the ability of institutions to do that, and particularly where federal or state funding are involved. They're not really allowed to discriminate on the basis of race, and affirmative action is a form of discrimination. So what we've been doing is really taking aim at these issues wherever we find them. We find them in public employment. We find them in public and private education. We find them in government contracting and grant making. And we find them in loan forgiveness. We find them in so many other places. And so we're really playing whack-a-mole as these things come to our attention. But you're correct. The White House has really taken aim at the big ticket item of the elite institutions of higher learning, which are not coincidentally the worst offenders when it comes to treating people on the basis of race as opposed to individual merit.
I'm just curious, my own thoughts here. I had heard when you first came into office, and this is kind of the fighting the swamp thing, almost half of your entire department just got up and left. What has that been like in the pursuit of dismantling all these DEI initiatives around, with also battling kind of the internal swamp at the Justice Department, or at least hopefully getting rid of that while you're there?
Well, pushing quota-based and outcome-based DEI is a holy grail of the left, really, and the civil rights movement. And in the first Trump administration, they really didn't take aim at this. They kind of laid low. And the second President Trump administration is bodily and forcibly confronting these inequities and injustices in our system. And so that's my job, is to really frontally confront these issues. And so I made it clear to the lawyers in the Civil Rights Division, there were over 400 of them at the time, that their job was to follow the law as the United States Supreme Court has decreed in Students for Fair Admissions and other cases, as the law of the statutes of the Civil Rights Act themselves indicate, and also as the president's executive orders, which also have the force of law, require. And that caused over 200 lawyers in the Civil Rights Division to quit in the first couple of weeks of my tenure. But that trend hasn't really stopped. We now have over 300 lawyers who've quit, including a couple this week. So I think that's actually a good thing overall when you look at alignment of the organization with its goals. We really don't want people working here who are opposed to our goals. And, I don't want any lawyer having to do a job and punch a clock every day and don't believe in the outcome. Unfortunately, the law dictates what our outcomes are here in the Civil Rights Division, and, they can practice law elsewhere if they like. So we are looking to hire and bring in lawyers, not of any particular viewpoint, but commitment to the rule of law is an essential sine qua non of being hired here in the Civil Rights Division today. And that means something different than it did a few years ago.
And you can probably confirm that you're not making any DEI hires. You're just looking for the best and brightest, I would imagine. I saw you on, I think it was a judiciary panel, where you got into the idea of individual liberties versus this kind of collectivist nature. And that's probably a little bit more in the weeds than we generally get on the show, but I really would like you to expand on that thought, because I thought it was really interesting and also super important for how the U.S. citizen, the U.S. populace looks at what the government is supposed to do. Can you kind of expand on that a little bit?
Well, yes. I mean, the founders of this country were part of a stream of really radical thought in sort of an Enlightenment period, where the concept was the elevation of man or woman as individuals with individual rights and individual responsibilities. That's very different than frankly, thinking of most cultures historically, and certainly radically opposed to the Marxism that we saw in the 20th century. And DEI is really a form of Marxism. It's a form of collective justice and group think and group outcomes. And frankly, to be more clear about it, a system of racial spoils and a concept that we can right prior wrongs committed by individuals by punishing people today who had nothing to do with that and giving people spoils today who had no discrimination against them. And so, these are at odds with the founding principles of our country, our Constitution, and our Declaration of Independence. And so I feel very good about being in the position of being able to return the concept of civil rights to individual responsibility, individual opportunity, and not group outcomes.
Yeah, I would happen to agree. Where do you see the biggest hurdle for the civil rights approach that you're taking at the Justice Department? And I know you probably can't comment too specifically, but of the states, the institutions, the localities that are pushing back, who do you see is pushing back the hardest or the most difficult to kind of get through?
Well, I'm not sure it's difficult as such because the law is on our side, but there are competing concerns. So for example, a competing concern in being articulated when we go after these universities for grossly violating the rights of Asian and white students and discriminating against male applicants and so forth as well, academic freedom. Well, we have the right to academic freedom and so forth. I don't really think that's quite on point, but what we're not doing is getting into micromanaging these schools as we're talking to them about correcting their wrong practices. They can go ahead and teach Marxism and women's studies and ethnic studies and underwater basket weaving all day. It may affect the extent to which they qualify for federal funding if what they're doing is inconsistent with the national interest, but they can there's no rule that says that schools have to get federal funding. So that we're doing a sort of a case by case analysis. But the other limiting factor is frankly just personnel. A lot of people left the Civil Rights Division, and if I had a full complement of people here, we could be doing a lot more, but we're doing a lot with what we have so far.
I might be totally out of my depth as a guy who's definitely not a lawyer, but with all of these cases that you've got going on, how much, precedent do you think you're going to be setting versus how much you're just enforcing existing law that has already been decided, they're just deciding to break it, if that question makes sense?
Yeah, no, we're doing both. That's a great question. First of all, you start with implementing the current law, but look, in my entire career of over 30 years, I've been pushing the envelope on all of these issues already. So it's actually been very gratifying to see the United States Supreme Court, while I've been sitting in this position here in this office, agree with some of the aggressive positions I've taken in, California in trial and appellate courts on issues like, I sued Google over discriminating against a white male engineer and telling him he was inferior. That was a cutting edge case. Today, that's the law. Today, the United States Supreme Court in a 9-0 decision authored by Justice Ketanji Brown Jackson said that there are not different standards for white or black or any color or category applicants under Title VII, our federal employment discrimination statute. Everyone is treated equally. What a radical concept. But the court had not articulated as such until this year, although some of us lawyers like me have been doing that, taking that approach because we saw that that was the trend of the law for years. We have cutting edge cases happening right now in the Voting Rights Act area as well. United States Supreme Court has taken up a case involving racial gerrymandering that may drive the stake through racial gerrymandering, which has been a way of life in protecting safe districts for minority candidates, as well as, frankly, safe districts for Republicans around them for decades. And, these definitions are changing. It's very interesting. Texas is trying to do redistricting this week, and that's all the drama with these legislators who've gone on the run to Illinois, a very gerrymandered state itself. That is all kicked off by a letter that I sent to the state of Texas over 4 districts in Texas that are inconsistent with federal law. And now it's very interesting that the governor announced that the redrawn districts also include several districts that are majority minority, but they will be competitive for Republicans and Democrats to as a jump ball. Like both parties can compete for those. They're no longer safe for one party or the other. That's America. Demographics change, political viewpoints change, and we shouldn't be locked into some racial spoils that are institutionalized.
That is fascinating. In kind of wrapping up, is there anything, I mean, we talked a lot about the DEI. Is there anything that is on your docket that the American people should look out for in the coming months and coming years?
Well, gosh, there's so much that we're dealing with that we haven't had a chance to get to. K through 12 discrimination, transgender related issues are something the DOJ is tackling head on. We have the first ever Second Amendment section coming soon into the Civil Rights Division, where we will be standing up for the rights of American citizens vis-a-vis their gun rights under the Second Amendment. That's a new thing that we instituted here under my leadership. And so we're really excited to redefine what civil rights means for Americans within the meaning of the law, but also current priorities of this administration. And I'm really thrilled and honored that President Trump and Pam Bondi put their faith in me to do this job.
Yeah, and we're all excited to see you guys, probably not the terminology I should use, but crack some heads over there at the DOJ. It's been really interesting to watch, and we're looking forward to everything you guys have coming down the pike here. Assistant Attorney General Harmeet Dhillon, thank you so much for taking the time.
Thanks for having me.